matter of William R. Woodward, Department of Public Safety and Corrections, Office of State Police, docket number 21251-RV. Good morning.
Good morning, Commissioner. Adam Karamanis here on behalf of Trooper Woodward.
I'm sorry, I missed your name.
Adam Karamanis, K-A-R-A-M-A-N-I-S.
Good morning, Michelle Gerard on behalf of the Department of Public Safety, Office of State Police.
Just to be sure, no witnesses were subpoenaed for this hearing. Mr. Karamanis, do you have any witnesses that you intend to call?
No, ma'am, I don't.
And Ms. Gerard?
We have some stipulations. It's really the documents that are relevant to the appeal before you that we're going to introduce. I do have a witness here that I can call, or if the commissioners have any questions for him, I can tender him the questions regarding the two documents we're going to submit.
Why don't you go through the stipulations?
The first stipulation we have is to a document which is 2 pages. I've labeled it as J1. It's a receipt that's signed by Master Trooper William Woodward dated March 31st, 2021, and attached to it is a letter dated March 31st, 2021, addressed to Trooper Williams that is the notification that he's the subject of an administrative investigation. The second document is J2. It is a letter dated March 29th, 2021, addressed to Colonel Davis and others from Captain Eric Quinker, Troop F Commander, and that document outlines a DWI arrest that Trooper Woodward made on March 24th, 2021, with attached documentation, and that document is 5 pages. With that, I'd like to introduce and file into the record J1 and J2.
Which of those documents were provided to Trooper Woodward at the time he was provided notice?
J1, that is the notification letter in the receipt that shows the date you got it. And I have copies for the commissioner.
So the joint exhibits are admitted into evidence.
Any
Wait
other
till everybody gets a
stipulations?
hold of theirs before we get, we'll just wait till everybody gets theirs then. Mr. Karamanis?
So as the commission likely recalls, the reason we're here today is because Trooper Woodward received an insufficient notice of the investigation that he was the target of. When we last left off, the commission put the question forward, well, what did the state police know? Well, as you can see right now from J2, it should be page 3, the letter from Captain Cuenca to IA requesting an IA investigation in no uncertain terms provided that they were requesting that investigation because of what Trooper Woodward, how he operated the intoxilizer and how he documented the results thereof from the DWI arrest. Now, state police has maintained that the notice provides sufficient allegation of the facts that he's being investigated for, but that's simply not true. I don't want to repeat what we've already gone over, but the policy they cite is so impossibly broad that it's impossible for anyone to receive that notice and have any idea of the actual substance of the factual allegations that are being made against them. And more importantly, this evidence shows that state police had that information on hand. They could have easily provided that information, and they chose not to do so. And I want to be clear what we're seeking here today. We're not here challenging Mr. Woodward's discipline. He received a letter of reprimand as a result of this investigation. What we're here today seeking is a ruling from this commission that any notice that any other trooper receives from here on out that fails to sufficiently detail the facts of the allegations being made against that trooper does not pass muster. It's not valid. The the state police has to be held accountable. They have to follow the laws that this commission established and is tasked with enforcing. These laws are there to secure and protect these troopers' due process rights. A trooper cannot enter these interrogations having no idea what he's about to be asked, having no idea what the substance of these questions are about to be. These interrogations are crucial parts of the investigatory process. The implications are that they are critical, that they can affect a trooper's job, everything from a letter of reprimand to termination, as this commission knows. And so for a trooper to enter that environment and to be the only person in the room who doesn't know what the interrogation is about to focus on, while simultaneously being the only person in that room who has anything to actually lose as a result of that interrogation, the harm is clear from that. And so again, Your Honor, what we're seeking here is a declaratory ruling that any notice similar to this one that does not provide the substance of the factual allegations being made against the trooper does not pass muster and is invalid.
So, I want to make sure I understand clearly. So, Trooper Woodward is not seeking any remedy other than a declaration in this case, is that?
Correct.
Okay. And it's your contention that this is ripe for a decision by us, even though he is not seeking a remedy for himself?
Correct.
And on what basis would you make that argument?
The basis...
Under the rules, what basis would you make that?
Troopers are allowed to appeal violations of the rule that negatively, adversely affect them. This flows directly from that.
All right. And that actually brings me to the other point I was going to raise. There was more than one question that was asked last time we were here. It was not just what did the police know, but I specifically recall asking for some presentation of where the adverse effect is. After we denied the summary disposition, we had further discussions where we pointed out, this doesn't mean that how we're going to rule at the time we have a hearing. Let's hear the evidence of what they knew and where's the adverse effect. I see what they knew. I see nobody presenting any evidence on the adverse effect.
Well, again, the adverse effect is clear. This is a process that implicates a trooper's job security. He has a property interest, as you know, in his job. There's a due process that the state police must follow in order to investigate a trooper. Any violation of that process is clearly harming that trooper's rights of due process. This commission made these rules. This is y'all's rule. I didn't just dream this up. This is a rule that y'all promulgated, that you are tasked to enforce. We heard that argument a lot last time. We know it's our rule. I understand. I know I'm probably repeating something you've already heard, but it bears repeating, though, that this is what this commission's been tasked with, protecting a trooper's due process rights. And I want to be clear, we're not challenging the state police's ability to investigate troopers or anything like that, just that those investigations have a clear set of rules that they must follow.
Anybody else have any questions?
Do you rest, Mr. Chairman?
I do want to add one more thing.
Sure. I wasn't trying to cut you off. I'm sorry.
It's also worth asking where's the burden on state police if the commission were to make such a ruling that I'm asking for? The burden would simply be that state police would have to add 1, maybe 2 paragraphs to notices like the one they sent to Trooper Woodward. That's it. This is the bare minimum that we're asking for. We're not asking for some Herculean effort or task for the state police to undertake. We're just asking for them to satisfy the rule as it's written. That's all we're asking for. Yes.
Mr. Wolf?
Commissioners, the request that's being asked for here is a declaratory ruling, not just in this case, but it seems to be expanded to other cases that are not before the commission properly at this time. So if there is any entertainment of a declaratory ruling that the notice was deficient, I would think it would be proper to limit it to this notice that's before the commission. With regards to the argument that the notice was deficient, it listed a DWI arrest that occurred on March 24th, 2021. And in petitioner's own petition, I believe it's in paragraphs 6 and 13, which should already be a part of this record, He outlines specifically issues that could arise from that DWI stuff. Specifically, it states he made a DWI arrest on March 24th, 2021. Aside from a minor issue with the intoxilizer on the first attempt to obtain a sample, the arrest was fairly routine. And then in paragraph I believe it's 13. It says, instead of complying with the rule, the LSP seeks to ambush Trooper Woodward, leaving him to guess as to the factual allegations being made against him. For example, does LSP take issue with the basis for the traffic stop, with the manner the traffic stop was initiated, with the manner the traffic stop was conducted, with the initial interaction between Trooper Woodward and the violator, with the manner he performed the standard field sobriety test, with the interactions between Trooper Woodward and the violator during the test, with the manner Trooper Woodward took custody of the violator, with the manner Trooper Woodward transported the violator, with the manner the chemical breath test was administered, with the interactions with the violator during or after the administration of the breath test, with the manner Trooper Woodward affected the arrest of the violator, with Trooper Woodward's reports or paperwork in connection with this arrest, with any other of a myriad of issues related to this DWI arrest. The notice that it relates to the DWI arrest he made on March 4th, 2021 could entail any of those issues. And you don't know what the issues are until you start conducting the investigation and get into the facts of it. Trooper Woodward was not cited with not cooperating with the investigation. He was not disciplined for that. So with your question, Mr. Chairman, is where's the adverse impact? He was able to fully participate in the investigation, otherwise he would have been charged with not cooperating.
I don't know if it's one necessary to quote and the other that he'd be charged with not cooperating, even though he could not fully. I don't know that I can draw that logical conclusion, but I am still grasping for some information on the adverse impact.
There was none. He stated to it that there was no appeal of the discipline, and even a declaratory ruling in this case, there's been no adverse impact, so it wouldn't remedy anything in this case, and I think it would be inappropriate to apply it to any other case. That's not before the commission at this time, possibly.
Any of the commissioners have questions for the department?
So I have a question.
Commissioner Meredith.
Can we ask, or is it from the court in regards to the notification being sufficient or not? And as far as that in regards to 12.8, contain such information will fully inform the employee of the conduct for which the action is based, and which enable him to prepare for defense, including wherever pertinent to date, time, place, and affected by such conduct, etc. Is that, can we ask questions in regards to that, or is the?
That's a different
That rule is not
notice.
applicable to this.
Okay.
That would come after the investigation of him. If they then chose to proceed with discipline, then you have what is called a pre-disciplinary letter, letting them know that you may discipline him, give him a chance to respond, and then you have a letter of discipline. This is all before that. These are rules concerning the investigations prior to pre-disciplinary.
So the actual informing the trooper as far as the violations or potential procedures that he violated, is that in question in regards to the department providing him with enough information?
What's in question is what is required under Rule 12.13, the notice there. That's where the focus is. The 12.8 would come later.
Okay.
And wouldn't we only address that question if we believe that this is an appropriate appeal?
If there was an appeal based on discipline, discipline, yeah.
Thank you. All right, I'm clear on, thank you.
Anybody else?
One question.
Yes.
Ma'am, just so that I'm clear, you guys were investigating him based on that entire, you guys reviewed, that investigation reviewed that entire DWI arrest, correct?
Yes, if you look at J2, there were a lot of things pointed out that were in question that you don't know what actually occurred until you open and ask your questions and conduct your investigation.
Absolutely, ma'am. And so your notice to him, as I read it, told him just that. We are investigating this DWI arrest, which means everything in its totality, anything that happened from start to finish with that DWI arrest, correct?
Right, and I don't think it's been disputed ever that he only made one DWI arrest that day.
Yes.
Okay.
For some reason, I had in my mind that there were two that day, but there's only one.
Two stops.
He
One
pulled it out.
DWI.
One DWI
One was
arrest.
speeding.
One DWI arrest, correct.
All right, thank you for the clarification.
I would like to point out to the commission that the erosion of a trooper's due process rights is a harm in and of itself. Again, these are sacred constitutional protections that every trooper is entitled to. The erosion of these rights is a harm. And I also want to point out, Ms. Giroir listed all the potential things that he was being investigated for. Well, why didn't the state police include that? They could have easily included a statement, including but not limited to, and then provided the whole slew of things they wanted to investigate. They chose not to when they had all the information in front of them. And again, this wouldn't limit the state police's ability to investigate. Once they're investigating, they can follow the facts wherever they may lead. They're not confined strictly to what the notice says. The investigation might start out with what the notice details, but if they start investigating for something connected to that, that's fine. We're not alleging anything about that. We simply say that when a trooper receives a notice, that notice needs to give him enough knowledge to prepare for an interview in which his job security is threatened at that interview based on what he might say there. Again, he's entering this interview. He hasn't had time to jog his memory. He's not sure what they're talking about. He doesn't know exactly what's going on. And the rules don't say that the state police needs to give him a rod and a reel and enough tools to go on a fishing expedition. The rules say they need to provide the substance of the factual allegations being made against the trooper being investigated. Thank you.
Just one thing is with
Real
regard
brief, Ms.
to the due process, I'm not sure that these rules rise to the level of a constitutional due process. I'm not aware of anything in the Constitution that says these investigations have to be conducted in this manner. So as far as it being a violation of due process, I'm not sure it rises to a constitutional violation. There's been no evidence that Trooper Woodward was not allowed to prepare for the interview. He, the one DWI arrest, he wrote a report relating to the arrest, so there's been no testimony or evidence that he was not allowed to prepare for the interview.
Thank you. We'll consider the matter submitted. Commissioner Rickey has made a motion to enter into executive session. Been moved and seconded. Take a roll call vote.
Ronnie Crawford,
Yes.
Glenn Knapp,
Yes.
Robert Mears,
Yes.
Harold Perry,
Yes.
Sabrina Richardson,
Yes.
Jared Ricky,
Yes.
and Ulysses.
Yes.
Just take it easy.
Into public session in regards to the motion in regards to the matter of William R. Woodward, Department of Public Safety and Corrections, Office of State Police, docket number 21251-RB. And I would like to make a motion to deny the request to declare that this notice, the notice contained in this particular case was deficient for lack of substance of the factual allegations being made. Can I have a second?
Second.
Got a motion and a second. Any discussion? All in favor?
Aye.
Any opposed?